Welcome to the Workmen's Land Reform Update webinar, the Lay of the Land. This is our first webinar in our history, so we're very excited to be able to keep close to our clients under these unprecedented and uncertain times. Thank you for joining us, and what we're hoping to do today is to provide you with an overall update on key developments and issues that impact land reform and property. So stay tuned. What we've got on the offering, we've got 4 speakers. Speaking to you right now is Bulelwa Mabasa, head of the Land Reform Restitution Practice Area and a director in the team. The presentations are going to start with Anelengidi, director in the practice area. She's going to be taking you through the laws of eviction, the beneficiary allocation policy, followed by Refilwe Mwisi, who will take you through the National Spatial Development Framework Act and related legislation. Followed by Refilwe Mwisi is an associate in the Land Reform Practice Area, and she will be followed by Thomas Carberg, who will be talking you through compensation as a concept and Section 25 of the Constitution. And lastly, I will, given my experience as an advisory panel member advising President Cyril Ramaphosa on land reform, I will then be taking you through the recommendations that have been taken forward post the report. I do believe that there is a live feedback feed that you should see from your side, which you can field your questions as and when we go. However, there will be an opportunity to ask questions after each speaker. Thank you and stay tuned.
Good morning. My name is Anelengidi, as Bulelwa Mabasa indicated. Thank you very much for joining us this morning. Ordinarily, we do this face-to-face, but in the circumstances, I think a webinar will be just as great. And we hope that you'll enjoy your time with us this morning, and we will get to share a few insights that we have into the work that we do, and our views on what is currently happening in the South African law. So I will be dealing with the beneficiary selection policy that was published. The white paper on South African land policy of 1997 states that the purpose of land redistribution program is to provide the poor with land for residential and productive purposes in order to improve their livelihoods. Land restitution is intended to assist the urban and rural poor, farm workers, labor tenants, as well as emergent farmers. However, despite various land reform policy efforts initiated in the post-1994 period, more than 2 decades later, the inequality of land ownership has been left relatively intact. So expropriation without compensation has been a hot topic in South Africa and sometimes a political tool for some parties, and has been touted as being the solution for the land issue. The amendment of the Constitution that Tom will discuss has also been a significant topic of discussion. Contrary to popular belief, a number of amendments to the Constitution of South Africa have been effected since its inception. However, none has evoked more divergent views and garnered as much attention and public debate as the proposed amendments published in the 18th Constitutional Amendment. What the amendment has also required us to think of is what other alternatives are available to us instead of expropriation. The Department of Rural Development and Land Reform has published a new national policy focusing on land allocation in South Africa. This policy was gazetted on 3 January, and the policy notes, despite the various land reform policies initiated post-democracy, very little has actually changed in terms of who owns what. The last day for you to submit comments on this policy is the 30th of March, 2020. So So most corporates who have land that don't utilize or wish to donate often highlight the fact that there isn't a clear, objective document that sets out who would be the beneficiaries of land that they can make available for the purposes of land reform, thus negating the need for the state to expropriate. This then obviously brought to light the beneficiary selection and allocation policy. The primary objective of this policy is to provide a uniform, fair, credible and transparent process and criteria for selection of beneficiaries for land allocation or leasing of state properties. To help these issues, the policy has set out a number of principles which aim to redistribute land more equitably. We'll now discuss these various policies. These policies include equitable access to land. Government aims to strive to promote conditions which enable all previously disadvantaged citizens and targeted groups, being women, youth, people with disabilities, and military veterans, to access land. Another concept or principle that's introduced or proposed by the policy is the online application system and the National Application Register. All applicants will be expected to lodge applications online, and there will be walk-in centres which will provide applicants with the necessary assistance when submitting their applications. This is to ensure that a credible and transparent system of an application process for land allocation and beneficiary selection is implemented. Another policy that has been introduced is land allocation and a selection panel. An independent panel has been proposed, and which will be established to ensure that a credible and transparent land allocation and beneficiary selection process occurs. This is important as this panel will contain a body of adequately skilled persons who will have a vast range of knowledge and skills in determining and assessing applications received. These are people who would be skilled in various issues such as economics, agriculture, and the like. This is a good solution. However, there is a concern that the existing institutions don't need yet another panel to place further strain on an already strained fiscus within the various departments. Another principle that the policy refers to is to aim to address diverse land needs. Government shall need to ensure that all land needs are equally addressed, i.e., agricultural production, commonage, human settlements, industrial development, and other needs. The primary focus has in the recent years or in the past been in the context of restitution and primarily been aimed at agricultural land. And when you really talk to people as to what are their needs in terms of land, not everyone wants agricultural land and not everyone wants to be a farmer. So this diverse policy is going to close those gaps in relation to what do people truly need in terms of land. Then there's also going to be an upskilling of beneficiaries. Government shall be required to promote conditions which will enable a selected beneficiary to graduate and to produce at the level at which matches the potential of the allocated farm. This is also a new directive or principle in that previously, or in terms of the current dispensations, there is no directed or concerted effort to ensure that the recipients of land are given the necessary skills to ensure that the property that they ultimately receive is commercialized or utilized to its full potential. There's also a drive towards the commercialization of black farmers. Government shall ensure that it rekindles a class of black commercial farmers which were systematically destroyed by the 1913 Natives Land Act. Also, the bias towards poor rural residents and municipalities will also be addressed in terms of this policy. Government shall ensure that rural, poor, landless, or poor municipalities and peri-urban residents gain access to land for production, commonage, human settlements, and industrial development. The policy also seeks to target women and youth women and youth through land access. Government will need to ensure that the land allocated reaches out to women, unemployed agricultural graduates, and youth in the agricultural sector for participation in agricultural production, economic activities, and associated agro-processing value chain opportunities. This will be a much-needed relief, especially in light of the current unemployment plight that we are currently experiencing, especially in the context of youth. So the prioritization of youth in this context is quite important. There will also be a needs assessment and a skills audit that will be conducted. All applicants shall be subjected to a skills audit and assessment before being allocated land to inform the type of training that they require. A concern with existing programs is that communities are often given properties that are not provided with the necessary skills or assistance to maintain or commercialize the properties. Hopefully, the skills audit and needs assessment will close that particular gap. So the question is, now who will qualify in terms of this policy? The policy states that who will not qualify in terms of this policy. The policy provides that the following people will not qualify under the proposed system: no non-South African citizens, previously advantaged South African citizens. And on the point of non-South African citizens, Thomas and I have written an article on what exactly are the rights of non-South African citizens in the context of access to housing and other associated benefits. This came in light of the recent judgment of the Western Cape High Court, where the court was required to give its views on the non-South Africans who were occupying the Green Market Square in Cape Town. So going back again to who exactly does not qualify in terms of this policy, it's foreign nationals and illegal immigrants, employees of the Department of Agriculture, Land Reform and Rural Development, politicians holding office. However, there will be a cooling off period of 12 months after leaving public office, and current beneficiaries of land distribution programs, where a person has been allocated a property or a farm and has abandoned the property, vandalized it, or mismanagement. This is a requirement that's quite important to ensure that there is no double dipping on the part of beneficiaries. Again, who also doesn't qualify? Farmers or individuals or legal entities currently leasing a state property unless he or she intends to hand the quality of they intend to return the current property back to the state. State employees shall also not qualify unless they undertake to resign from the state. Traditional leaders who are recognized under any legislation in the country are also not going to be allowed to benefit from this particular policy. Then this begs the question, who does qualify? All previously disadvantaged South Africans over the age of 18, women and people with disabilities as previously indicated, military veterans, natural and naturalized persons or legal entities, and communal farmers, township dwellers, and state residents and other individuals. So what this policy doesn't make specific mention of is land expropriation, and Thomas will take you through this during his particular presentation. The publication of this policy is also as a result of the report prepared by the advisory panel, and you will note that significant principles in this policy are adopted directly from and reference the policy. Bulela, as one of the panel members, will take you through her recommendations on the panel's reports and what has been adopted. This takes me to the next important policy that we now have. This is the Mine Community Settlement Guidelines, published in December 2019 by the Department of Mineral Resources. It is an important policy as it is the first time that the DMR seeks to codify resettlement guidelines. Relocations and resettlements in the context of mining are often very complicated, highly charged, and highlight the inequalities between traditional communities and the mighty mining companies. Over the years, courts have been called on for various reasons to pronounce on disputes between mining companies and the communities, who often just want to be simply heard, to have their traditional way of life respected, and to be treated with respect and dignity. So the guidelines demand that mining companies engage in meaningful consultations with these communities if the relocation is required in order for the mining to take place. The resettlement guidelines are also intended to outline the process and requirements to be complied with by an applicant or a holder of a prospecting right, mining right, or mining permit when such an application or right will result in physical resettlement of the landowners, lawful occupiers, holders of informal and communal rights, mine communities, and host communities from their land. These resettlement guidelines extend to existing prospecting rights, mining rights, or mining permits where incremental project expansion will have the effect of displacing all resettlements of landowners and other affected persons. These guidelines add that the consultation process would need to give the communities a chance to obtain clear, accurate, and understandable information about the impact of the proposed mining activity or the implications of the decision to relocate. So this policy provides that mining companies will assist with the resettlements by providing financial and related support to affected communities and offer support after resettlements to ensure that the people's livelihoods and standards of living are restored. Companies should also assist with the sustained development within the resettled mine community after a resettlement. However, the document says that in order for the consultation to be meaningful, it must be aimed at giving affected parties with the chance to comment on the resettlement options, and should it fail to yield the desired results, an aggrieved mining company or the community can take the matter to court. The draft guidelines are, however, already being challenged by non-governmental organizations, especially since the President recently signed the Traditional and Khoisan Leadership Bill into law. Also, strangely, the policy seems to suggest that parties must approach courts for assistance, whereas recently the Constitutional Court in the Maledu and Olubeni judgments have rather indicated that people must first approach the regional manager of the DMR before, in terms of Section 54 of the Act, before approaching the courts. So what does the resettlement guidelines require? They require that mines implement a resettlement plan. What is a resettlement plan? A resettlement plan is a broader consultative document which is concerned with project description, impact analysis, cost and budgetary considerations, and consultation mechanisms. In this regard, affected stakeholders to be consulted will be told about the nature and extent of proposed operation and the area and specific considerations. In terms of resettlement guidelines, an applicant or a holder of a prospecting or mining right must conduct a stakeholder mapping to identify and profile stakeholders that must form part of the meaningful consultation process. What is a resettlement action plan? This is also a document that has now been introduced by the guidelines. A resettlement action plan is a document that lists what steps must be taken in order to achieve the goal set out in the resettlement. The purpose of the resettlement action plan is to clarify what resources are required to reach each goal, to formulate a timeline where specific tasks need to be completed, and to determine what resources are required. Then finally, a resettlement agreement must also be concluded. This document will serve to record in full all the commitments that have been made by the mining rights holder in the resettlement plan and the resettlement action plan, and it should outline the rights and obligations of all the parties concerned. In terms of the resettlement guidelines, no mining activity may commence until a resettlement agreement is reached on the appropriate amount of compensation as a result of the resettlement of the landowners, lawful occupiers, or holders of informal rights and communal rights or host communities. So what if the relocation is not effective or the occupiers do not want to relocate? Well, in terms of the guidelines, the parties must approach the court. In my view, which is informed by the Act and the recent case law from the Constitutional Court that I referred to earlier, parties must first go to the DMR in terms of Section 54. The problem with Section 54, however, is that there's very little confidence in this process, and regional managers who are responsible for managing these proceedings often cannot resolve the impasses between parties, and this can lead to extended disputes and the holders of mining rights not being able to implement to execute their rights insofar as the communities either remain or they are unable to do so as it would adversely impact the people affected. Also, the lack of clarity in the Act is also itself a problem, as it does not give specific time periods within which these proceedings must be finalized, which also doesn't assist. So all in all, it's a necessary document or guideline to provide mining institutions with the necessary assistance in relation to relocations, especially considering the historical context and historical relationships between mining companies and communities. Thank you very much.
Thank you very much, Anele. It's Bulelwa back here on the microphone. Our next speaker, as indicated initially, is Refilwe Mwezi, who is a senior associate in the practice area. She will be taking you through the National Spatial Development Framework. At this point, if you are connected through our link and you have any questions, you're able to click on the link, which will enable you to ask questions as and when we speak. So we're not going to pause now for questions. We will be able to view your typed questions on the link.
Thank you so much, Bulelwa, for the introduction. I am going to be taking you through the Spatial Development Framework and the Democratic and Constitutional Dispensation. Spatial transformation is something that is quite recent in our law, and it was first envisaged by the African Charter, the African National Congress Freedom Charter of 1955, and in that regard it reads as follows: We, the people of South Africa, declare for all our country and the world to know that South Africa belongs to all who live in it, black and white, and that no government can justly claim authority unless it is based on the will of the people. That restrictions of land ownership on a racial basis shall be ended, and all that land shall be redivided amongst those who work it, to banish famine and land hunger. The state shall also help the peasants with implements, seed, tractors, and dams to save the soil and assist the tillers. There shall be freedom of movement and shall be guaranteed to all who work on the land. All shall have the right to occupy land wherever they choose, and people shall not be robbed of their cattle, and forced labor and farm prisons shall be abolished. And all people shall have the right to live where they choose, to be decently housed, and to bring up their families in comfort and security, and unused housing shall be made available to the people. Slums shall be demolished, and new suburbs shall be built, and we all have transport, roads, lighting, playing fields, creches, and social centers. And it is against this backdrop that the national, the SPLUMA, the Spatial Development, the Spatial Planning, and Land Use Management Act was enacted. So let me just take back. So here you can see the stark inequalities that occupy the South African space, and that actually informs the need for spatial transformation. So here you see the stark disparity between two areas in the Western Cape. So on the right-hand side is an area called Hout Bay in the Western Cape, and just on the adjacent side is an informal settlement called Imizamo Yetu, which are just divided by the road. So it is against this background that the need for spatial transformation exists. In 2013, the Spatial Planning and Land Use Management Act, which are colloquially referred to as SPLUMA, was enacted, and the purpose of the act was to provide a framework that will regulate spatial planning and land use management in the Republic, that will provide for inclusive, developmental, equitable, and efficient spatial planning at the different spheres of government, that will provide for a framework that monitors and coordinates the review of past spatial planning and land use management systems, and to ensure that such systems promote social and economic inclusion, to address past spatial and regulatory imbalances, and to promote greater consistency in the application and decision-making procedures for land use and development applications. When does SPLUMA apply? SPLUMA applies to all development applications, but most importantly, it applies to the entire Republic of South Africa. And it is legislation that is enacted in terms of Section 155 of the Constitution and Section 44.2 of the Constitution insofar as it regulates provincial planning. And except as provided for by SPLUMA, there isn't any other legislation that may provide for legislation that is contrary to SPLUMA. Although SPLUMA was enacted in 2013, the commencement date of the Act was the 1st of July 2015. The important sections within SPLUMA are Section 12, which provides for the preparation of spatial development frameworks in the context of national, provincial, and municipal spheres of government. Section 13, which provides for the development and publication of an NSDF in order to take account policies and plans of public and private entities that impact within spatial planning and land use, and within the land development space as well. It also includes any other matters that may be relevant to coordinate such policies, and all the representations submitted by the Minister of Rural Development and Land Reform in respect of the framework and related matters. And in addition, there's an obligation on the Minister of Land Reform and Rural Development to revise the NSDF every 5 years to ensure that it accords with recent times and to put it in line with SPLUMA. Section 14 of SPLUMA is also quite important, as it mandates the Minister mandates for an NSDF to be formulated, and such NSDF must give effect to the development norms and standards as prescribed in the purpose of SPLUMA. It has to give effect to the relevant national policies, priority plans, and legislation, as well as coordinate and integrate provincial and municipal spatial development frameworks, and enhance spatial coordination of land development and land use management activities at national level, and demonstrate desired patterns of land use in the Republic of South Africa, and to give effect to the environmental management instruments and considerations. Section 24, is also quite important in the context of land use schemes, in that it prescribes that it must include provisions to promote the inclusion of affordable housing, which we will deal with later on in the presentation. And Section 35, most importantly, provides for the establishment of municipal planning tribunals, which are tribunals that handle spatial land use management and land development applications. And such tribunals must determine land use management, as I said, and development application within its municipal area. However, the land development application can be categorized in those that may be considered by a municipal official and those that may be referred to the tribunal. I'm not sure how effective or whether in principle such tribunals have been put into use, but however, there have been several municipalities that have operating procedures of how these tribunals are going to operate. Section 40 is also quite important in that it says that the Municipal Planning Tribunal may designate at least 3 members that will consider the application before it, and at least 1 member must not be a municipal official. So Section 40 provides for the constitution of such a tribunal. Obviously, if 3 members of the team adjudicate over an application, there will be the presiding officer and 1 non-municipal official, and the other one will be a tribunal member. It is important to note that such members of the tribunal are obligated to be transparent in their decision-making process, in that they're required to take detailed minutes in order to be able to provide them to the public should the need arise in the future. We are going to now discuss the draft National Spatial Development Framework, which I'll refer to as the NSDF. There's been various drafts that have been prepared, and the latest one being the 2019 draft that has been prepared in terms of Section 13.4 of SPLUMA. This draft was published this year on the 20th of January 2020 in the Government Gazette, and was published for public comments, and the comments closed on the 20th of March 2020. The NSDF gives effect to the principle as set out in the purpose of SPLUMA that we've discussed previously, and the purpose of the NSDF is to provide a long-term guiding light for realization of desired post-apartheid national spatial development pattern. So the NSDF consists of 7 parts, which we will not discuss in detail. We'll just merely highlight what those topics are within the NSDF.
Sorry, I'm going to pause at this stage because it seems from our feedback page that some of you are having an issue downloading the slides where it says the page is not found. We've been informed by operator that in order to resolve that problem, you just need to refresh your screen page on the browser or press F5, F for father. So refresh the screen page on the browser and press F5. So I'm going to let Refilwe carry on. But also what we will be able to do, because we've got a record of who's on the call, we will make a point of emailing all the slides to all the participants. So I'm handing over to Refilwe to continue.
Thank you, Bulelwa. As I was still discussing that the NSDF consists of 7 parts, being part 1 sets out the overview and the background and the need for NSDF, which is in line with spatial transformation and post-apartheid spatial development. And part 2 sets out the process followed in the compilation of the NSDF, with part 3 providing a high-level overview of the significant national spatial development dynamics, and part 4 setting out the national development vision, part 5 setting out the national spatial development and investment guidance, part 6 setting out how the NSDF can and will be implemented, and finally part 7, which provides a summation and conclusion of the NSDF. I think it's important to set out what the NSDF is. Such a huge document, but I think it is important to set out what its focus is. And the focus is to target and direct all infrastructure investment and development spending decisions by all national sector departments and state-owned entities. It's to guide and align plan preparation, budgeting, and implementation across spheres and between sectors of government, and to set out a framework and coordinate provincial, regional, and municipal spatial development frameworks. It is important to implement the NSDF policies because urbanization and the movement of people from rural to urban areas has increased significantly, and the population of people now living in urban areas will continue to rise up to 2050. And the 3 urban areas, urban regions, Gauteng, Western Cape, and eThekwini regions, will experience the largest increase in population, and this is a result of natural growth, as well as immigration within the Republic of South Africa. And there's going to be a significant movement from people from villages and small towns to larger, better connected towns, which are located on major transport routes where provision of better and more reliable basic services, education, healthcare, and policies are and will remain important drivers for migration. However, while small towns and dense rural settlements are not expected to see a large population growth, they are also not expected to see a significant population decline in either the medium scale or high growth scenario for population growth in South Africa. And as such, both large urban areas and rural areas will require targeted and appropriate government focus and attention. And the outcomes of the NSDF are to ensure that there's a consolidated and quality settlement, that consolidated and quality settlements are provided with the necessary social and economic infrastructure for fast-growing population, that national urban regions and nodes act as national and global gateway for trade, tourism, and national political functions, and gateways for such African and regional integration. And that high-density urban nodes provide opportunities for interaction, innovation, and enterprise development within existing, as well as new, inclusive, and interaction-centered enterprise economies. However, high density or urbanization may have an impact on the very access to socio-economic amenities that urbanization seeks to cure. So in other words, people are more likely to move to urban areas to seek better opportunities and better living conditions. However, if spatial transformation does not take adequate measures to prepare for such, urbanization may actually have a dire impact on such socio-economic needs of the minorities. And what I mean by this is that we have illegal electrical connections because people are living in backyards and shacks. This results in a lot of people being congested in the urban areas, and they may be built below par housing, which we'll see in the next slide, and that there's burning of municipal water, sewage, and waste disposal resources. A case in point is Hammanskraal, where there was no access to water for such a long time, and one can only imagine the dire consequences of that in the current pandemic that we're facing, that where people are required to wash hands quite significantly, and people don't have access to water. One can only imagine the dire consequences of that in light of this COVID-19 pandemic. And there's poor water and sanitation resources provided to people, and there's little or poor access to healthcare and poor access to education, which might ultimately result in a high dropout rate, which leads to unemployment and crimes within the poorest of the poorest. And as such, a well-developed service infrastructure system acts as a basis for just access to high-quality social and other services. There we see an example of a poorly constructed RDP, which is a reality for many of the poor of the poorest. And there we see an example of what poor access to sanitation looks like. And with that being said, I'm going to now move into the inclusionary housing policy. So now, what is the City of Johannesburg inclusionary housing policy? It is a land value sharing mechanism where the city or the municipality incentivizes the development of affordable housing by requiring developers or new development applications to reserve a certain percentage of housing units in their market rate development for low or moderate income households and through other means. So it's a policy formed in accordance with the NSDF, the NDF, the COJ Spatial Development Framework, and the Integrated Urban Development Framework. This policy was approved by the Johannesburg Council on 21st of February 2019 and was effective from the 23rd of May 2019. And what is the purpose of the IHP? The IHP addresses stark inequalities in the city of Johannesburg because we know that, as we saw in the picture in Hout Bay and Imizamoyethu in Joburg, that there's a stark disparity between those living in the cities and those living in informal settlements. And its purpose is to facilitate access, as I said, of the poor to economic opportunities and social amenities, and to increase the supply of lower income housing to the poor, for the creation of more mixed income groups across the developments within the city, and create affordable housing to and in areas that are well located to access job and amenities. There's also a mechanism for land value capture in favor of the city and its residents, and to ensure that investments in the city benefit large and diverse portions of the population and affect the spatial transformation. What are the requirements of the IHP? So the IHP within the city of Johannesburg will apply to new land development applications in respect of residential accommodation for rental or ownership purposes, where residential or mixed-use development applications are made for 20 or more residential units to be built. And this application must include at least 20% affordable inclusionary housing, and this inclusionary housing will be in place in perpetuity, and they can either be voluntary applications to new applications where less than 20 units are being built, and where this mechanism is used, such people will be privy to the incentives that are afforded by the city, and inclusionary housing must be built on the same site or in the same township. And this will be the difference between the City of Johannesburg IHP and the City of Cape Town IHP, as we'll see that in the City of Johannesburg, people are actually mandated. Affordable housing is actually, it is a mandate that affordable housing has to be built in the same development area, which is the difference to the Cape Town IHP, as we'll later see. And the incentives that are afforded in terms of the IHP are an increase in floor area ratio and an increase in density to accommodate extra units or parking space. We'll now move forward to discuss the City of Cape Town IHP. So the principles are similar to that of the COJ IHP, but most importantly, the City of Cape Town IHP is still in draft form for discussion purposes, and the requirements are less stringent than the COJ IHP, in that the policy does not set out a firm criteria of how it applies to who and when. However, what is important to note about this IHP is that it gives an option of on-site contribution, which is building the affordable housing within the same development of the application, or off-site contribution. So it means that affordable housing can be built off-site, which my view is a lot of development applications within the City of the City of Cape Town, will make use of that. Or you can also contribute to a municipal fund, which will be ring-fenced, and such funds will be dedicated for the building of affordable housing. So my view is that the City of Cape Town IHP actually works against spatial transformation, because if you give people the choice of whether or not you are going to build affordable housing within the same development off-site, or contribute in monetary in money, people are obviously going to make use of off-site building or contributing to the municipal fund. And that brings my presentation to a conclusion. Thank you very much.
Thank you very much, Refilwe. Mr. Mutheo Landane, or Miss, sorry if it's a miss. We have received your two questions, the one dealing with the public participation issue in the proposed constitutional amendment, and there basically you're asking to what end, when does the public participation process conclude. In this case, I think it's safe to say that for the amendment to pass, it would need a 2/3 majority vote in Parliament. And you ask that there's been 190,000 submissions and only 8% were in support of the amendments. I think it's an ongoing process, and the Joint Constitutional Committee, which was formed in Parliament to run with this, has a fundamental and phenomenal task at taking into account all of these submissions, but ultimately it'll have to pass as a 2/3 majority vote in Parliament. And that question leads me nicely to the next speaker, Thomas Carberg, who will be taking us through to his proposal. Before I move on to Thomas, the other question that was framed by Mr. Landane is the issue around SPLUMA, to say who takes priority between the private sector and the people, where, for example, private sector wants to build a golf course, and how does that act promote inclusion of affordable housing. The issue here is that that's precisely what SPLUMA tries to do, is that it tries to integrate local, provincial, and national needs to an extent that each province or each local authority has to work in accordance with the spatial development framework. So in other words, what you're asking is who will then have the last say in terms of a development that is suitable for that. And this is precisely why SDFs are important. Refilwe wants to comment because this is her baby. I'm going to hand over the microphone so she can tackle this SPLUMA question before Thomas joins us again.
Thank you, Bulelwa. I think a point that I should have made clear earlier on is that the inclusionary housing policy applies to new development application within the residential space. So it's not in the context of commercial spaces or commercial developments. but will only apply to new development applications for purposes of residential. Thank you.
Thank you, Thomas. Over to you. You're going to take us through Section 25 and compensation provisions. Please, if you do not still have access to downloading the slides, please make use of the feedback link. We are seeing your questions from our side.
Good morning, everyone. My name is Thomas Carberg. Thanks, Bulelwa, for the introduction. I'm the most junior member of the team. I've been here for less than 3 months, but I'm here to give a brief overview of the provisions in the Constitution regarding compensation, the old 1975 Expropriation Act, which is currently still in force. Then I'll briefly touch on the draft expropriation bill, which is currently still under negotiation, as well as the Constitution 18th Amendment Bill, which aims to amend Section 25 of the Constitution to allow for land expropriation without compensation. I'll also briefly touch on differing views regarding the constitutionality as it currently stands under the provisions of Section 25 as they currently are of expropriation without compensation. In order to facilitate this discussion, I just want to briefly explain what we mean by an expropriation so that we have a common foundation from which to proceed. An expropriation is defined as an administrative action taken by a state. In an expropriation, the state is exercising its unilateral power of eminent domain, which essentially means that property can be expropriated without requiring the consent of the property owner. Another central feature of an expropriation is that it deprives an owner of all his or her property rights in relation to the specific property, as opposed to only some or certain of the property rights. Consequently, ownership would vest in the state, not in a private person, after an expropriation. The two main features of an expropriation are that it must be done for a public purpose and that it must involve the payment of compensation. In the South African Constitution, under Section 25, subsection 4, the Constitution states that land reform does form part of the public purpose. Also, the provision regarding compensation in Section 25 states that compensation must be just and equitable as opposed to strict market value, which is the case in some other jurisdictions. I'll touch on these provisions again later when I set out the provisions of Section 25 as they currently stand. The previous Expropriation Act, which was promulgated in 1975, the Pre-Constitutional Expropriation Act, is currently still in force. Just very briefly, under the 1975 Expropriation Act, there are 4 requirements for valid expropriation. These are an authority to expropriate, which would be a piece of legislation or an act of Parliament. Procedural fairness, which essentially means that the owner of the property must be given an opportunity to make representations as to why the property should not be expropriated. There must also be a public purpose and compensation, as I've touched on before. A public purpose, just to explain, a public purpose would usually be something like the construction of a road or the construction of a power plant or something along those lines. Section 12 of the 1975 Expropriation Act governs the payment of compensation. Under this section, compensation was divided into 3 categories, namely market value, actual financial loss, and solatium. The actual financial loss is a payment which is intended to make good the owner's consequential losses arising from the expropriation, whereas solatium is an amount that's awarded to the owner in respect of the inconvenience of suffering the expropriation. Market value under Section 12 of the old Act was defined as the amount which the property would have realized if sold in an open market by a willing seller to a willing buyer. This concept is known as the willing buyer, willing seller principle, and it's been applied by our courts since and prior to 1975, and it continues to be applied even in the current context, despite this concept not being found in the Constitution currently, as I'll explain in a moment. So the willing buyer, willing seller principle is essentially a method for calculating what market value compensation would be in a specific case. In the case of Southern Transvaal Buildings, which is a pre-constitutional case, the court explained that because of the complexity of applying the willing buyer, willing seller principle, this determination often ends up being an educated guess that a court has to do. So there are problems with the willing buyer, willing seller principle. So what you're seeing before you now is the Section 25, subsection 1 to subsection 4. This is not the whole Section 25, but these are the relevant provisions for the calculation of compensation and the protection of private ownership. Section 25(1), as you see there, essentially is the provision in our Constitution that protects private owners from arbitrary deprivations of their property. Subsection 2 states that property may be expropriated only in terms of a law of general application for a public purpose or in the public interest and subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. Very important provision in Section 25 is subsection 3. So this subsection governs how just and equitable compensation will be calculated in terms of the Constitution. As you can see, subsection 3 reads that the amount of compensation and the time and manner of payment must be just and equitable, reflecting an equitable balance between the public interest and the interests of those affected, having regard to all relevant circumstances. So this concept of the equitable balance is also found in several other constitutions, including the German Constitution. And the central feature is that the most important consideration is not market value, but the concept of an equitable balance, taking into account all relevant circumstances. These circumstances are subsections A, B, C, D, and E that you see in front of you. They include the current use of the property, the history of the acquisition and use of the property, the market value of the property, the extent of direct state investment and subsidy in the property, as well as the purpose of the expropriation. What this means is that market value, as it stands in the Constitution currently, is not the sole determiner of just and equitable compensation, but it's only one among several factors which a court will take into account when determining what amount of compensation will be just and equitable in a specific case. Subsection 4, as you see it there before you, is basically just provides that for the purposes of Section 25, the public interest includes the nation's commitment to land reform. And what this allows a court to do is to reliably or to be allowed to expropriate property for land reform as it includes the public interest. I just want to pause here for a moment and briefly explain that there's a debate regarding whether Section 25, as it stands currently, allows expropriation without compensation. Legal thinkers differ in this regard. For instance, Professor A.J. van der Walt has said that because of subsection 2, specifically subsection 2b, which states that property may be expropriated only subject to compensation, the amount of which must be either agreed or decided by a court. For this reason, Section 25 currently does not allow property to be expropriated without compensation. Other authors, such as Advocate Tembeka Nqokaitobi, argue that because of the provision that the amount of compensation must be just and equitable, it would be reasonable to assume that the Constitution can be interpreted in such a way that just an equitable compensation would constitute zero or null compensation in certain circumstances. So authors differ in this regard. I think if there are any questions with regard to that, it will be a great topic for discussion. Now I want to briefly touch on the Draft Expropriation Bill, which was published in Government Gazette number 42127, Notice 1409 in 2019. There was a previous version of this bill which was rejected by the National Assembly, and this version of the bill is currently still under negotiation. Essentially what this bill aims to do with regards to compensation, and I'll focus my discussion of the bill specifically to compensation, is that the bill wants to basically apply the constitutional provisions and transfer them into legislation and expand upon them. So we've just touched on the provisions of Section 25. So the bill would transfer those provisions into an act. The bill also identifies 5 circumstances where EWC, expropriation without compensation for land, may be appropriate. So you see these before you, the A, B, C, D, and E, where land is occupied by a labor tenant, where land is held for purely speculative purposes, where land is owned by a state-owned corporation, where the owner of the land has abandoned the land, or where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. This is not a closed list, but these are 5 circumstances that the bill identifies where EWC may be appropriate. The bill further prevents the following circumstances from being taken into account when calculating compensation: the lack of consent of an owner in the expropriation, the special suitability of the property for its purpose if it's unlikely to be purchased for that purpose in an open market, the value of enhancements arising from unlawful use of the property, any improvements to the property which were made after the service of a notice of expropriation unless agreed, any acts done for the purpose of obtaining compensation, and any enhancement or depreciation directly attributable to the purpose for which the property was expropriated. So this bill is quite controversial, and there have been several submissions which can be found online regarding the unconstitutionality or possible unconstitutionality of this bill. So these you'll find listed in front of you. Chief among them is that the circumstances where EWC may be appropriate are not a closed list. So this means that they could be applied by other circumstances could be argued by a municipality to also be deserving of EWC. In addition to this, there's vagueness in the bill. For instance, the meaning of abandoned land. Would this be 20 years, 30 years, 5 years? It's not made clear in the bill. As well as what land would constitute being held for purely speculative purposes. The bill doesn't clarify those concepts. There's further difficulties with regards to the procedure of an expropriation that the bill outlines. The procedure starts with negotiation between a municipality and a landowner. It then moves to an investigation into the property. After that, the municipality will serve a notice of intention to expropriate, which will invite representations by a landowner. These representations can, however, be rejected. Then the municipality will serve a notice of expropriation, after which ownership of land will automatically pass on the date which is mentioned in the notice of expropriation. So this means that there is a lack of judicial oversight or the need for a court order, which means that essentially a municipality can expropriate land without a court order or without a court supervising the process, which is a big problem that's been outlined. The bill also has a very narrow definition of expropriation, which would include other deprivations from needing compensation. This was discussed in the Agri-SA case. All right, the last thing I want to touch on is the Draft Constitution 18th Amendment Bill, which was introduced in December 2019. That's a typo there, my mistake. It was introduced in December 2019. So this bill is a much shorter bill and essentially aims to amend Section 25 of the Constitution to provide that the right to property may be limited in such a way that where land is expropriated specifically for land reform, the amount of compensation payable may be nil, and to clarify that such limitation is a legitimate option for land reform in order to ensure equitable access to land. So at this point, it's important to emphasize that the amendment bill specifically focuses on EWC for land reform purposes and not for all purposes. So you'll see here this would be what Section 25 would look like with the proposed amendments. Subsection 1 will be unchanged. Subsection 2, you'll see there under subsection B, the bill would insert the provision that, provided that in accordance with subsection 3A, a court may, where land and any other improvements thereon are expropriated for the purposes of land reform, determine that the amount of compensation is nil. So this would be just insert a caveat into the provision that property must always be expropriated subject to compensation. Subsection 3 would look like this if the bill would be enacted. Essentially, no substantive changes are made to the circumstances which a court must consider, but subsection 3A would be inserted, which essentially puts a mandate on Parliament to enact specific legislation where a court may determine that the amount of compensation would be nil. Let's assume that this would be the expropriation bill, which is still currently under negotiation. All right, that concludes my presentation. I hope that it's been helpful in just giving a brief overview of the constitutional provisions regarding compensation, the Old Expropriation Act, as well as the proposed draft expropriation bill and the draft Constitution 18th Amendment bill. Thank you very much.
Thank you very much, Thomas. What is now the last segment of our webinar will be run by myself, Bulelwa Mabasa, and actually my discussion points are very much linked to everything that has been discussed and presented in detail by Anele, Refilwe, and Thomas. So, moving on to the next slide, I'm going to take you through the recommendations that have been carried through past the, or rather pursuant to the final report of the Presidential Advisory Panel on Land Reform and Agriculture. What my talk will do is that it will, so what the previous speakers, Anele, touched on, she zoomed into a particular issue or particular issues such as beneficiary selection and also the mine resettlement policies. Those will feed into some of the recommendations that then have been carried through from the work that was done by the panel. And then Refilwe's talk around spatial planning, inclusionary housing issues, and SPLUMA issues, you will see how those issues have been carried through into the future of land reform. And then lastly, you will see how the current wording, the draft wording of the 18th Amendment Bill in Section 25 of the Constitution is similar to, although not identical, to the proposed wording of the section that was given in the panel report. So as you, just to highlight the relevance of the Presidential Advisory Panel work and processes, is that the President had appointed the panel on 18 September 2018. The report was submitted to the President on 4 May 2019. It was published on 28 July 2019, and affected and government departments have now all considered the report, and each ministry has responded to how the panel report impacts it. The report was grounded, I think, mainly on an intersection of issues that have been dealt with disparately, or rather as if they were not connected. So for the first time, we saw that the report was grounded on rural and urban linkages, agriculture and urban issues, addressing unique territorial characteristics. What we have seen in the implementation of land reform in the last decade and also was a neglect of urban realities. What you also start seeing rising through from the report are issues aligned with integrated urban development and spatial transformation and a unitary system of equitable tenure. So the work of the panel, or rather the Presidential Advisory Panel, did not have a blank page on which it grounded its work. The panel was obliged to work within terms of reference, specific terms of reference that we were given a mandate to look for under the mandate of the President. We were to provide a unified policy perspective on land reform in respect of restitution, redistribution, and tenure reform. We had to consider circumstances on which expropriation without compensation could be applied, the procedures to be followed, the institutions that would give effect to expropriation without compensation, the assessment and diagnosis of problems and limitation with laws and policies, to consider a policy on redistribution, and to consider a policy on compensation of land acquired by the state. I see now that there is also a question from Ms. Jody Johnson, who's asking whether land being held for conservation purposes will be seen as unused land. That is a very important question. One of the issues that we had considered as a panel was to say, when we look at the map of South Africa, we should be able, for example, to delineate and say land for conservation should be protected, and that that type of land, in my view, would not be seen as unused land, or that type of land would not be considered for expropriation without compensation. And the reason for that is that once land is conserved for conservation purposes, it is not suitable for land reform purposes. So it would not be suitable land for communities to settle in, and it would be at odds with current legislative and environmental legislation that, for example, will deal with NEMA and so on. So in other words, land reform is not supposed to undermine other legislative priorities such as the environment. So what then the Intergovernmental Framework Act does is that it impresses upon different arms of government, different government departments, to work in tandem in order to make sure that land reform does not conflict with environmental issues. So I hope that clarifies the question. I'm now going to move forward to a list of recommendations that we can all anticipate are now being implemented by the different departments. So the departments that were involved in the processes were the Department of Trade and Industry, Agriculture, Public Works, Mines, the typos, it's not justice constituency, it's justice and constitutional development, human settlements, water sanitation, mineral resources, and cooperative governance, and treasury. If we were to be given a mark for the work that the report that we did, we would be given, maybe, I don't know if it's an A or a B. What's 50 over 73? So of the 73 recommendations, 60 were supported, 10 were not supported, and 3 are noted for further analysis. The categories of recommendations can be broken down into 4 categories. One is National Spatial Framework in Transforming Human Settlements. 2 is Implications for Program Design. 3 is Accelerating Land Reform. and 4 is institutional reform. So, supported recommendations, one big issue is addressing immediate land hunger. What has happened, we're told that the state has released land, which is currently a work in process under the leadership of the Interministerial Committee. I would, in my personal view, be welcome an update as to what land has been released, where has it been released, and where is it being targeted. Because at this particular point in time, even with, for example, the President's State of the Nation address, we're not really given those details as to which land has been released by the state and for what particular use. Knowing that would have put us in a better position to assess whether we are closing the spatial gap or whether or not farmers are being supported. As Anele has brilliantly presented on the beneficiary selection and land allocation policy, we know that that is ongoing and that is on a public comment phase. This, to me, was one of the big takeaway points, and I think a sense of pride in the work that has been done by the panel, because never before in South African law and policy making have we had clarity on who must get the land and for what, and who would be excluded from getting the land. So that transparency, I think, is something that is welcome. The development of the Agriculture and Agro-Processing Master Plan has completed, and this is because we have not seen a integrated, consolidated, well-articulated plan on the future of agriculture, especially agro-processing. Here you might ask, potentially we could deal with the issue of development of the cannabis industry and all other economies that can flow from that to feed this industry. The land donations policy is another thing that Anele spoke about, and I think the importance of the land donations issue is that with the insurmountable, or rather seemingly insurmountable, challenges that South Africa has, there's a recognition that expropriation is not going to be the only way in which land can be acquired or made available. There's an understanding and a recognition that there is a place for public-private partnerships, there is a place for business to play a role, and so that a land donations policy could be a positive way that could also promote a sense of solidarity within the South African population when it comes to an issue that is seemingly so divisive. And we've also seen now with the COVID-19 news reports mentioning the R1 billion donation that has been made by the Oppenheimer and the Rupert families, that challenges that face our country can no longer be placed solely on the door of government. We're also talking about reforming tenure. Tenure in South Africa is a tenuous issue that if land reform were to be an issue that has to be resolved, tenure would be the biggest issue that would have to be resolved in law. So we're hearing about an upgrading of the Land Tenure Rights Amendment Bill, which has apparently been approved by Cabinet and submitted to Parliament for further processing. The reason tenure is such a tenuous issue that requires specific attention is that 80% of the South African population does not have rights, legal rights that are registrable, that are recognizable in law, which means that those people, then the majority of our country actually sits with insecure tenure where they could be evicted at any time because they sit at the periphery of the formal legal system. So we look forward to these amendments in order to address the big issues around tenure. Water policy reforms, I think there's been an acknowledgement that if you're going to provide land for land equity, you cannot do so without providing the concomitant rights to water. we're told that this is also work in progress. These, in terms of policy making and legislation, this slide that you see in front of you are bills that are currently underway that are intended to cure the defects in the current legislative process. The Deeds Transformation Policy and Bill is going to be a very important piece of legislation. The reason that this is so significantly important is that currently in our law, one is only able to register what is called real rights. And real rights are those rights that are defined in the current Act to mean rights that have legal protection that are registrable. As I have already mentioned, that 80% of our country's people do not interact with property in the manner that is defined in the Act. So what the Deeds Transformation Policy and Bill must do, and we hope it will do, is that it will bring within the fray the ability of citizens, whether black or white, rich or poor, the ability to hold land and to have their rights recognizable and enforceable in law. The Land Administration Policy Bill is also an important issue because as matters stand, the administration of land in our country is still disjunctured, where you do not find a complete record of land holding within the deeds registry if you're dealing with people that form outside of that. So the Land Administration Policy and Bill is going to seek to centralize the administration of land in South Africa so that hopefully in a click of a button you get to know who owns what land, where, how much, and what the land is used for. I've mentioned that there's going to be an agrarian reform policy that is also aimed at expanding the participation of people, smallholder farmers, black commercial farmers, smallholder farmers, into the supply chain of the agrarian economy. We also then can expect a revised white paper on land policy and land redistribution. And this must be read in line with the beneficiary selection and allocation policy as well. A land compensation policy and urban land policy will be built into the frame. What you see in front of you are just organizational and personal implications that are largely covered in line budgets. Areas that may have implications are, for example, what has been touted, a land court or so these are the institutions that are likely to be introduced. An introduction of a land court. What we have currently is a land claims court, which only looks at matters arising from ESTA, at the moment, ESTA being the Extension of Security Land Rights of Tenure Act, and not necessarily on all land disputes. So what you're currently sitting with, you're sitting with high courts that can hear urban PI applications, where the land claims courts are hearing rural-based, if you like, disputes, but with no singular land court that looks at all land disputes. And then we're going to potentially have a land reform and agrarian agency. So these are the recommendations, if you like, that have not been supported, or rather where government responded or gave a contrary response, where they've said that the agrarian reform vision to be developed, that will be separately done and it will not be part of the white paper. So it's not that the recommendation hasn't taken through, they've decided to position it elsewhere. The introduction of interventions to stop leasing on well-located land to the elite. Here, what the response was that there's a major land inequality by race and gender. Access to those that lost land as a result of racial laws is not complete, so prioritization is as a result of limited resources, not to exclude others. So what basically this says is that there won't be an exclusionary practice. There was also an issue around the panel saying that the Office of the Valuer General is not at the moment calculating is not meant to be calculating compensation for expropriation, but rather that you should be looking at value. The government response was a contrary response, but they have said that the office is under review of the Office of the Valuer General. Remember, the Office of the Valuer General is a central office that calculates the amount of compensation, amount of value in circumstances of land reform or expropriation. Again, the issue of the Land Administration Act, it was not as if the recommendation was ignored. What the response was is that the development of tenure-related policies is in progress and will determine the status and location of such in a piece of legislation. Well, we then as a panel recommended where to locate the functions of rural development, but obviously when President Ramaphosa did his latest shuffle, he resolved to merge agriculture with land reform. And so the establishment of a land rights protector was rejected on the basis that the envisaged land court bill would deal with issues around land justice. This brings to the end our presentation, and I'm looking at the screen and I'm not seeing any further questions or queries. We can, I suppose, await your comments. We are able to address them post the link. We are told that the link is available for you to go through at the comforts of your own home and convenience. As and when, please feel free to field any more questions that you may have. We will make ourselves available online. Thank you for staying close to us. You are all important to us. I hope that this time of uncertainty and lockdown will encourage all of you to find means and ways to stay close to each other. Thank you very much.